Please be seated. Next case is Jetty East Condominium Association versus the Army Corps of Engineers et al. We've allotted 15 minutes to decide.
Good morning, Your Honor. My name is William Hyde. On behalf of the appellants, I would like to reserve 5 minutes. Before I begin my argument, I would just like to make a wistful observation that I suspect this may be my last time arguing before this court in this building.
Well, you never know, Mr. Hyde.
That's true, but I would like to note that I was one of the first law clerks that moved into this building back in 1980, so that somewhat dates me. This case is a really very straightforward case. It involves an appeal from a summary final order of the Department of Environmental Protection, DEP, that summarily dismissed without a hearing a petition for a formal administrative hearing brought by my clients challenging a modified permit to dredge East Pass over in the Destin area. The department dismissed this petition because it felt that the modifications to the permit were not significant and therefore did not create a new point of entry. I vigorously disagree. I think that the facts and the law dictate a different result. And secondarily, even if the petition were deficient in some respect, under the department's rules and under particularly Section 120.59, an opportunity should have been afforded to file an amended petition. I would like to focus, however, on my first argument. The case arose when the department originally issued a permit to the Corps of Engineers to maintenance dredge East Pass. East Pass, if you don't know it, is a notorious pass in terms of shoaling up and filling in. And it did so. The department issued this permit to the Corps of Engineers, and it was promptly challenged by the original petitioners, the Sherrys and Donovans.
But Mr. Hyde, let's go back and talk about what the original permit said. Did it not identify specific areas where the dredge material was to be put?
Yes, it did.
Okay, and those areas were not on the east side, were they?
No, they were not.
Okay. Why wouldn't that have provided your clients with a clear point of entry at that point?
It provided them with a point of entry at that point, but the permit was not sufficiently objectionable at that point to cause them great concern. It is when they entered into a settlement agreement.
Even though none of the areas specified for the dredge materials were on the east side of the pass.
I think that was certainly a mistaken policy decision by the Department of Environmental Protection, but they let's say, elevated their mistake by creating, through a settlement agreement, a blanket prohibition.
Let me make sure I understand the wrong suffered by your client, at least what they argue, is that the coast, the beach area in front of their property, they believe, was required to be included in the area on which fill was placed.
Well, I think it's a pretty clear statutory requirement.
Well, I understand, but their argument isn't that you are harming my property by what you are doing, is that you should be placing the fill in front of my property to benefit me. That's their argument.
That is the department's argument. I think that's, doing a flip side, a little bit of a sophisticated argument of harm versus benefit. My clients certainly were suffering.
I don't take issue with the fact that the lack of benefit may cause a harm. That's not my point.
Yes.
But if that's the case, back to Judge Webster's question, why wasn't your client harmed by the provisions of the initial petition? And why wasn't that harm as clear as it was in the amended petition?
Well, it wasn't. I would say they were harmed by it, but the harm was not a draconian harm because it was a one-time dredging event. And we need to, and this is central to my case, this is not a one-time dredging event authorized by this permit. This is a 10-year permit. It will be in effect for 10 years, and there will be multiple dredging events, and it is now saddled with a settlement agreement and reflects the prohibition contained in the settlement agreement that there will be no dredged fill from the pass deposited to the east side of the pass on, for example, my client's properties. And that's the signal development.
Was the original permit not also a 10-year permit?
The original permit was a 10-year permit, but it just authorized fill to be placed in various spots.
None of which were on the east side.
That's correct. But in the course of 10-year permits, you don't just sit there and change, you don't keep putting sand in the same spot year after year as you do future dredging events. That might not be appropriate.
Wouldn't they have to change the language of the permit to authorize any dredge materials to be put on the east side?
Yes, they can do that.
But they would have to do that.
They would have to do that to change the permit language. But now, for future events, they cannot do it because the permit now contains a blanket prohibition coupled with a settlement agreement that I am sure that the other petitioners would want to enforce to keep any sands from the pass from being deposited on the east side of the inlet.
And I understand you may have an argument that the perceived harm to your clients is greater as a result of the new permit than it was as a result of the original permit. But I still fail to see why you didn't have, why your clients didn't have a clear point of entry when the original permit was issued, and why they didn't waive their right to a challenge by not asking for it at that point.
They had a point of entry to a speculative harm to them that has now been changed by a permit modification that makes the speculative harm into a 10-year recurring harm. And that's what is the significant modifying factor. I think that you have to look at these kinds of things practically from the point of view of lay people when they get notices of this nature. They think, for example, that they are going to, the department and the Corps is going to do what is appropriate under the law. And a decision was made to dredge the pass and place the spoil in certain areas. Fine so far. Yes, it would have been nicer if they had put the spoil on their beaches. They didn't do so. But then the permit is magically transmogrified into a much more draconian permit that not only doesn't authorize the placement of fill on their property, it absolutely prohibits any future placement of fill on their property. And that's a significant modifying factor. The permit is materially different when you include that kind of a prohibition. And I think that is the signal fact in this case that calls for the case being remanded to the Department of Environmental Protection for forwarding to an administrative hearing officer. And, nobody can test, for example, you can read the appellee's briefs. I sit there and argued in my initial brief that sections 161.142, paren 5, and paren 1 clearly make this a stated policy of the state of Florida to take dredged materials from federally maintained navigational inlets, such as East Pass, to place it on adjacent eroding beaches. Nobody in their answer briefs took any issue with the fact that what they have done through this prohibition is violate those rather express state policies. And I think that that's another factor, Judge Webster, that makes this, how can you sit there and say through a written modification to a permit that requires an illegal act, and I would suggest to you this is an illegal act because it's clearly in violation of those two statutes. How can you say that that doesn't create a new point of entry? The earlier provisions of the permit, as originally issued, authorized the placement of spoil in certain areas not on the east side of East Pass. Now it creates a written prohibition manifestly in violation of two state statutes prohibiting the placement of fill on the east side of the pass. And if you didn't say them in my appendix to the brief, we have had instances in the not too distant past, Tropical Storm Ida, with storm water surging underneath the building's pilings and foundations. So this is not a silly argument that we're bringing here. And it's something that...
And I don't know that anybody is suggesting that your argument with regard to the statute is silly. I think the real problem, at least as I see it, is whether we ever get to that argument.
I understand that that is your concern, but I think that you need to look at the practical effect of the original permit versus the practical effect of the altered permit.
How is the Rudlow decision significantly different from this case?
I think the Rudlow decision dealt with a situation where a marina was challenged subsequent to a modification, and the environmental impacts of that marina were considered not to be greater, and that was something within the general ambit of what could have happened during the course of the administrative proceedings. In this case, what's different is the department took an action that might not have been illegal on its face at the time, maybe just bad policy, in refusing to put sand on clearly eroding beaches adjacent to the pass. It decided to sign a settlement agreement and incorporate into the settlement agreement a prohibition on the placement of fill that is clearly and indisputably in contravention of 2 state statutes. That's what's different. There's nothing in the Rudlow case that suggests anything of that sort. And with that, unless you have any questions at this point, I will save the remainder of my time for rebuttal.
You have just under 4 minutes.
Good morning. May it please the Court. My name is Kelly Russell. I'm representing the Department of Environmental Protection and the Board of Trustees in this matter. I'm going to reserve 5 minutes for the co-appellees to be able to...
I'm going to move this so that I can see you.
I appreciate that. Okay. Judge Webster, you basically stated exactly what the arguments are, simply that it was clear from the original permit what the department was authorizing. It was very clear, and it's not disputed that the petitioners or the appellants were given a clear point of entry, that they did receive public notice through a newspaper publication. That newspaper publication clearly stated that the agency action may change or be modified or result in a denial. Therefore, if you have some substantial interest, this is the time. It gave time frames for these people to file a petition, and no petition was filed.
Well, it seems to me, counsel, that the one thing the parties agree on is that the issue here is did the addition of the language pursuant to the settlement constitute a substantial modification of the permit such that there's a new point of entry. And the appellant argues that the additional language really constitutes a prohibition, not in the first permit, that is contrary to statute and therefore illegal. So it is that the amendments have created a higher burden. Would you address that fine point?
Yes, Your Honor. The amendments did only simply clarified what was already in the permit. What was in the permit stated the sand or the dredged sand will be placed at these approved areas. I actually did bring visual aids. They're in part of the record. These 2 drawings, sheets 1 and sheets 2, are from both the original permit and the revised permit. The drawings didn't change. This is what I'm showing you is simply an index of the drawings. It states what the drawings are that are attached to the permit. The second drawing shows that the location of proposed dredging and disposal location. And then on sheet 2, which again did not change between the original permit and the final permit, shows the locations of the fill material through the chart. So none of the dredged material was allowed to be placed east of the channel. None of that changed. There were...
Under the original permit, would the department have had the authority or power to have placed any fill east of, on the east point, east of East Point?
Your Honor, that's a good point. Actually, no. The department would have had the authority, but the department still has that authority. What would happen with the original permit, if that had been issued, would be that the applicant must come in, actually, during that 10-year period, if they wanted to place the material anywhere other than where it's located on these maps or drawings, they would have had to come in and request a formal modification of the permit.
So what you're saying is under the first permit, they couldn't do it. Under the second permit, they couldn't do it without a modification of the permit?
Yes, Your Honor.
So that the second permit didn't do anything different than the first permit?
No, Your Honor. Should the appellants actually have wanted the sand to be placed on their properties, again, the time to come in and state that to the department would have been at the initial point of entry. In order for the Army Corps of Engineers, even if that permit had been issued, if the Army Corps of Engineers wanted to place sand, if the appellants, the property owners could have convinced them we really need that sand, then they would have had to come in for a modification of the permit and meet all of the statutory requirements. And as far as the statute, obviously we don't really get to that issue because there was a clear point of entry and the department didn't consider the Chapter 161-142, but it's absolutely false that the department wasn't following its statute when issuing this permit originally as drafted and as revised. It's completely consistent with statute. You can't pick out a few portions of the statute and say it's inconsistent with those. You have to read the statute.
Well, the modified permit, it seems to me, if you wanted to place sand east of East Pass, under the modified permit, you not only would have to go through the process of amending the permit, but it seems to me you'd have to go to the intervenors with whom the department has entered into a settlement agreement and obtain their consent, wouldn't you?
No. The settlement agreement simply states that if there are any modifications to the permit, that the department must give notice to the intervenors. And that's what we would have to do anyway.
Allow them to come back in and argue against it.
Yes. They'd have the same right. Everyone would have the same rights as if we issued the original permit as originally drafted. So with that, I actually have more time. I was thinking I only had 5 minutes left. The other point is that Rudlow is the controlling decision here. It's not different than where we are at the moment. Rudlow actually states that whether changes in the permit were substantial is irrelevant. If the intent to issue remains constant and the individuals are on notice that the final conditions of the permit might be different from those that were proposed. And here it's exactly that instance where the department intended to issue a permit for a certain activity. That's what we did. People were on notice of our intention and the proposed activities, and none of that changed. The appellants are trying to create issues of fact where there are none. It's very clear just from the record and from the actual original permit and the revised permit or the final permit that there were no substantial modifications to the permit, and therefore no second point of entry was created. First, they did miss their first point of entry. Second, no second point of entry was created. Any change that was made to the permit could have been anticipated at the time the original permit was issued by review of the original permit. And I think that's very clear at this point. In addition, as far as if there's a second point of entry created, the department defines major modification to permits. It's within several rules, including 62-312, and it defines a major modification as based on the magnitude and nature of the proposed change and the potential for environmental harm or effects different than those previously determined by the department. So here again, if you look at these two permits, the original draft permit and the final permit, it's very clear that there was no major modification of that permit. There would be no different impacts from one to the other. They're exactly identical. With that, I believe I've covered everything. So in closing, it's clear from the record that the appellants missed their point of entry to challenge the permit. They did receive the published notice, or it's not contested, and they waived their right to the administrative hearing. It's clear from the record, and it's clear from the petition that it could not be cured, and therefore it was appropriate for the department to dismiss the petition with prejudice. And we'd ask that the court affirm our order dismissing with prejudice. Thank you, Your Honor.
Are you going to argue too? Yes. Okay. You have 6 minutes, 30 seconds.
Okay. Great. Thank you, Your Honor. May it please the Court. Kent Sapert with Hopping Green and Sam's on behalf of Appellees David and Rebecca Sherry and John and Margaret Donovan. I'd like to address just a couple issues, 3 points. The permit revisions were not substantial. Rudlow controls this case, as the Court has already noted. 2, the reasons for the permit revisions. And 3, the non-applicability of the 2 statutory sections, 161 and 142. As discussed earlier, in its simplest terms, what the permit modifications did was make an implicit prohibition explicit. That's all it did. It didn't change anything with respect to where the sand was going. Appellants had an opportunity to argue to get the sand in front of their property. They missed that opportunity. The reasons for the permit revisions. Previously, under the old permit, there had been an opportunity or there had been a case where sand was not being diverted to the west, that it was stockpiled in one of these approved areas, and then by separate permit to the city of Destin, which we believe applied some political pressure, truck that sand back east towards the appellant's property. That was my client's concerns with this implicit prohibition. They wanted it to be expressed. They wanted nothing left to chance or interpretation down the road, since this was a 10-year permit. So that was the reasons for the change. And again, it changed nothing as to what was authorized or not. With respect to the settlement agreement that was entered by the properties, paragraph 10 of that settlement agreement specifically says that if there's a modification to the revised permit, my clients simply have to be provided notice so that they can, within 14 days, challenge whatever modification the Corps of Engineers seeks. It doesn't prevent a modification, as suggested by the appellants. Lastly, with respect to the application of the 2 statutes, the appellants cherry-picked 3 words out of that statute. And those words are adjacent eroding beaches. They grab those words and they imply that their beaches are adjacent eroding beaches per that statute and that they're required to get the sand. If you read the language of that statute and the intent, and I will quote it in 161-142 sub 1, accordingly, the legislature finds it is in the public interest to replicate the natural drift of sand which is interrupted or altered by inlets to be replaced, for each level of government to undertake all reasonable efforts to maximize inlet sand bypassing to ensure that beach quality sand is placed on adjacent eroding beaches. The clear intent of that statute is to make the sand go where it is naturally going, that is stopped or blocked as a result of inlet and jetties. And in this case, sand has always gone from east to west.
Counsel, isn't this the merits argument that the appellant would have made had they been able to make an entry?
That's exactly right, Your Honor, because they could have challenged that under the original permit.
I understand, but my question is why are we raising that here? Because that would have been something that might have been on appeal had they made an entry into the proceeding.
I agree with that, Your Honor. They missed the opportunity to raise that issue, but I wanted to discuss it on the merits as well, because it's been raised that it has no merit to that argument.
Well, but how do we know that? They've not had an opportunity to put any evidence on.
The language of the statute is clear that the intent for the sand is to go the way of the natural drift, and in this case, natural drift is east to the west.
How do we know the natural drift is east to west?
From the East Pass Inlet Management Plan, Your Honor, from the permit.
And we're to take judicial notice of that?
No, Your Honor, but again, the department, when they issued the permit, followed this statute, which was to make the sand go along with the natural drift. That's
Well,
the
I know
department's
that's their
determination.
position, but
Right.
the other side's position is, look, we never had a chance to argue whether they did or not.
Well, they missed that when on September 29th during
I
the
understand
publication.
that's your position.
And that's why it's inappropriate to argue that now on appeal, Your Honor, but I want to address those merits. If there are no
Just
further
out of
questions.
curiosity, which side of the pass are your clients on?
My client's located west of the pass that would receive the natural drift of sand as permitted by this project.
I assumed as much. Thank you.
If there are no other questions, I'll rest.
You might want to just put that poster board down so y'all can see what's going on. You might not want to see what's going on.
Your Honors, very quickly.
About 4 minutes, Mr. Hyde.
Regarding, I think you really hit the nail on the head. The sand bypassing issue is a factual issue. We contend that it's actually sand moves back and forth across the pass. And since we're talking about matters outside the record, a new inlet management
We don't
plan is
want
in
to
the
talk
process.
about matters.
I think we probably ought to stop
Second.
talking about matters outside of the record.
Second, and more importantly, I think that there is little doubt that this revised permit's express prohibition on the placement of the sand on the east side of East Pass violates these statutory mandates, or at least there is a factual issue that is not appropriate for summary disposition through a summary final order by the Department of Environmental Protection. And interestingly, neither DEP nor the other appellees ever disputed this, I think hoping that the court would likewise ignore it. Third, and I think most importantly, if the revised permit did not materially alter the original permit, then what was the purpose of the settlement agreement? And what was the need to revise the original permit, if not to require a prohibition that did not previously exist? To me, that is the question that you really need to answer.
Your opponent's answer to that, if I understood it correctly, was all they wanted to do was make explicit what had been implicit in the original permit.
I would suggest to you that that's a factual inquiry. And this is the one that I certainly raised as a disputed issue of fact, whether the permit itself constituted a material alteration of the original permit. It's not something that's ripe for summary disposition, and it's something that should have been forwarded to the Department of Environment, the Division of Administrative Hearings.
Is it your argument that under the original petition, Phil could have been trucked, that's the word that the appellees used, from the location on the west side of the pass to a location on the east side of the pass after it had been placed in the dredging operation?
That's a complicated question legally and environmentally.
Well, that would have been
Well,
contrary
it seems to
to
me
the
that was
permit
their,
itself, wouldn't
yeah,
it?
it seems to me they, if I understand their position, one of the reasons they wanted the settlement agreement was to prohibit the trucking, not the dredging, but the trucking of the dredged fill from the west to the east.
That may have been the case in the past, but again, why do they get to enforce that kind of a prohibition and on the department's exercise of its discretionary powers? Certainly, my clients had a desperate need for sand in front of their property, whereas these the appellees trying to enforce the property is located miles down the beach. Certainly not quite the same situation. And I think, again, it's a factual inquiry, certainly something that might be raised as a matter of policy or scientific argument before an administrative law judge, but it's not something ripe for consideration by this court. It's a factual dispute, and I think it should have been forwarded to DOA for that kind of a dispute, or at the very least, to afford us the opportunity to plead the allegations of standing and materiality through an amended petition instead of summary disposition of one first filed and only petition.
Well, and of course, again, all of that assumes that we, as a court, get over the argument that your clients waived their only point of entry.
Right. And if that's the case, then it was a pretty narrow point of entry, and something that I think will allow administrative agencies like the department to run roughshod over people if and when they materially change permits. It's just going to encourage people to jump into administrative proceedings, whether they have an abiding interest or not, just in order to possibly protect their interests, should they be somehow altered in the course of separate administrative proceedings. That's a policy decision that you should consider.
Good deal for lawyers, though.
Could be, and a bad deal for our clients.
Thank you, Mr. Hyde. Thank you all.